Parliament has been afforded a temporary respite after the High Court suspended the implementation of Chief Justice David Maraga's advice to President Uhuru Kenyatta to dissolve the bicameral Parliament. Justice Weldon Korir, in his ruling, certified urgent a petition filed by Lena Conchella and Mohsen Abdul Munassar. And as Francis Gashuri reports, Justice Korir's findings that the duo's application raised weighty constitutional issues paves the way for a legal showdown between a tag team of Parliament and the Executive against Maraga barely 3 months to the lapse of his tenure.
The 12th Parliament that was facing an abrupt end to its 5-year term has been handed a lifeline, albeit temporarily, by High Court Judge Weldon Korir. Korir, in a verdict on a petition filed by Lena Conchella and Mohsen Munassar, contesting Chief Justice David Maraga's advice to President Uhuru Kenyatta on Monday to dissolve Parliament, termed the application extremely urgent and that raises weighty constitutional issues that require to be addressed with all parties present. Maraga had invoked provisions of Article 261 sub-Article 7 of the Constitution to advise the President to dissolve the 2 chambers of Parliament for failing to enact the gender equity principle law, even after High Court Judge John Mativo in 2017 gave the 11th Parliament 60 days to pass the legislation or be sent packing. Judge Korir, however, issued orders suspending Maraga's advice to the President pending the hearing and determination of the Conchella-Mohsen petition or until any other order is issued by the court. The 2 petitioners had accused Maraga of acting in an unreasonable, irrational and irresponsible manner that could plunge the country into a political and constitutional crisis. The High Court judge found an arguable case in the petitioner's application and merit in the grounds they raised in the petition. The duo had, for example, said the Chief Justice failed to advise for dissolution of Parliament 3 years ago when Judge Mativo's orders were not implemented by the 11th Parliament, and that dissolving Parliament now would make it impossible for IEBC to conduct by-elections in 290 constituencies and 47 counties without finances that can only be approved by the dissolved Parliament. The judge, in his ruling, delving into questions raised on whether the President, if he heeded Maraga's advice and dissolved the August House, would be interfering with the term of Parliament. The petition filed by Conchella and Mohsen, according to the judge, requires the court to interpret and harmonize Article 261 of the Constitution and provisions that establish the term of Parliament. President Kenyatta has remained silent on Maraga's advice, despite various parties pushing him to send members of Parliament home and trigger a mini-general election. Judge Korir, however, said Kenyatta was not bound by timelines and can act on Maraga's advice any time, and that once he acts, the resultant events would be irreversible. This, according to the judge, means Kenyans should not be subjected to parliamentary elections before the constitutionality of Maraga's decision was interrogated exhaustively. He ordered the matter be heard by a bench of not less than 3 judges constituted by the Chief Justice and directed the petitioners to serve all the respondents and interested parties in the case for a mention of the case on the 7th of next month. The verdict was preceded by a flurry of activity, including a meeting at Parliament buildings convened by Speaker of the National Assembly Justin Muturi and attended by Attorney General Paul Kihara Kariuki and Solicitor General Ken Ogeto, politicians weighing in on the Chief Justice's Monday bombshell.
Given there's not even, in my view, a dysfunctional IEBC, is it really thinkable that this country can go to an election on account of this advisory?
Francis Gashuri, Citizen TV.